loved ones. Welcome to episode 8, Prayer of Relief, brought to you by Divergence Live. How about a disclaimer to start? Here we go. Serena is going to take care of introductions today. And as for what we're doing here, we've had a couple of requests respecting what's our immediate intent, where's this going, what's its direction, things of this nature. This is what we're doing here.
Just one moment, guys. We're having technical issues. In the meantime, Serena, if you want to carry forward.
Sure can. Hi, good morning, good evening, whatever it is in your part of the world. It's morning here in mine. Thanks very much for coming along, and all those who come every day. That's amazing to see. Etiquette rules for today, guys. Please keep your cameras on at all times, showing full face, not blurred or half hidden or halfway down below the cam. Please ask questions in the chat. Be very clear on what your questions are and put a question mark after it if it is a question, because we are copy and pasting them for later if they don't already get answered. And with that, please enjoy the rest of the amazing conversation of Darren. Thank you.
Yes, and also in the chat, there's already the link for the document for today. So if you guys want to go ahead and save that right away, and we will also include the link to the Telegram group once again, in case you guys haven't joined, which Darren has been answering some questions as well. So there's definitely lots of equity nuggets in there. Well, to make the most of this, in the meantime, if you guys have any questions at all, no matter where you are on the scale of learning, if you could please enter them in the chat right now. So as Serena said, we will be covering them later, but this really helps in Q&A, and also it helps us kind of know the direction we want to take, like more pinpointed for our further episodes. So if you guys could do that, that would be really, really wonderful. And apparently I just really want to talk to you guys today. We did have our Aliens in Equity from our kindergarten class. There is a YouTube link. So if you guys, you can find it on the Divergence Facebook group or on a Telegram groups. That one had tons of equity nuggets, tons of correlation between what were considered aliens and why. And it's just a very, very loaded 2 hours that you guys can get a lot of information from. So I strongly recommend you guys also check that out.
Another thing as well too, which I forgot to mention, was you can record these sessions with your own devices. You can't use the Zoom to record. It will only allow one. So if you have other devices, you can record as well. or be very fast with taking notes.
Hello, everybody. Can you hear me?
Yes, we can.
Oh, that's a good start. So does that mean I can, okay, so what I can do then is, I guess Kim can share the doc. I can speak over it, even with my video off. So I guess we can try doing that. And if that doesn't work, Kim can actually take the documents and start rolling through it, and you all can take screenshots of it if need be, however you'd like to save it for yourselves, and we could get it done that way. Kim, it's not, it's just, sorry. Okay, yeah, so Serena, you want to just continue?
Okie dokie. So I shall just get the download, and you want me to screen the download for you? Or have they gone again? Sorry, I just blocked my screen.
No, I think we're still here.
Okie dokes. All right.
If you can just, did you do introductions already, Serena?
Yes, I've already done the introductions.
Fantastic. Perfect. We'll get right into the document then.
Sure. Yeah, excellent. Okay, so again, welcome to episode 8, Prayers of Relief. This is my favorite part of the bill. Next to the charging part and the stating part, you put these two together, and this is the sandwich of relief that we're all looking for. So the 8th part of the bill is called the Prayer of Relief and begins with these words. You could actually insert right in here. Your Honor, may the petitioner have the relief, both general and special, that he or she prays by this bill or petition. You could literally have like a little subcategory there introducing this, and then literally you would roll into this as number 1. And that the said defendant, pretend you're the petitioner here, right? You can be sending documents to the defendant as notices. We all know that this is going to be parts of our process coming up. But anyway, so the defendants, upon being served with a copy of this bill or petition, may they or he or she or them be bound by all the proceedings in this cause, and that the other defendants, if there are any, because sometimes there are, right? When we're going to name the Crown et al., that means and others. So we're leaving a door open is what we're doing here. So that actually may come in handy later. It's better to leave a door like that open than to not open it, okay? So that these individuals, these persons here may make answer to your questions, and that, you know, you might stipulate in here that these questions are attached to a schedule, attached to an affidavit. You might want to just give a little context right in that little opening, and that the said defendants may be restrained by the injunction this honorable court grants from. But then again, so what is it the injunction is that you're seeking? Well, I want no proceedings brought against me, my personal property, anything of that nature until this is dealt with. So that is literally going to let the judge grant you a protective little bubble. So this injunction restrains the defendants from doing or acting or pretending to do anything that they may threaten you with doing, okay? And that these ends with the following concluding words at the end of your prayer. And here it is. This is what I was suggesting sort of in the beginning. And for such further and other relief as to this honorable court shall seem meet or shall desire to be fair, just, and equitable. What this is doing, again, this is setting the stage for the reliefs. Believe it or not, there's plural. You have general relief, and then you have special or alternative relief. Here's an example of the general relief. Any normal individual, man or woman, coming forward with claims like these, although they're rare, whatever it is generally that they would be entitled to the reliefs of, such as maybe I'm no longer subject to public health mandates. Maybe I'm no longer subject to taxation, penalties, fees, forfeitures, things of this nature, for all things considered public. So those are the general things, okay? Like that's cut and dry. Those are the things that the judiciary or the judges know. Everybody's going to ask for these. They're so general that they're actually called the general reliefs. Now, okay, moving on to the special ones. Okay, these are the ones specially related to the case that you're bringing. Now, again, there is a multitude of special reliefs that one can pray for. Primary ones, as I've mentioned in the past: injunction, accounting, specific performance, appointment of personal representatives, appointment of, get into it. Those 4 or 5, they'll literally encompass everything. If you wanted to get into certain other ones later, the sequestration, the marshaling, the tracing, tie those types of relief into your relief when you're praying for the accounting. Now, I'm going to get into this in a few more minutes here, but this is what they actually ask us to do. If you're going to pray for an injunction, do not pray for the appointment of a personal representative in the same bill. Believe it or not, they actually want us to break these things up. It's rare, and here's one example. I have seen them allow bringing the injunction and the accounting together in one bill. Okay, they allow that one for some reason, because I'm thinking it's, hey, stop that party, and then B, put me into a position where I'm entitled to at least some type of funding so I can put food in my mouth. Because part of that injunction is literally cutting you off from the legal world. So again, as an example, firsthand, this is actually happening today. One of the loved ones on this call this evening has had an account frozen because we fired off some important notices of interest and statement of interests. That's effectively this individual cutting themselves off from the legal world. So they literally have to freeze everything to see how that plays out, because they don't want to be held accountable if they make a mistake. If the creditor or if the beneficiary or the Dï5 et cetera, comes forward and demands the accounting, and then the accounting shows that there's a mess over here that hasn't been dealt with, that puts them in a liability, and that puts them in a precarious situation. They would rather not experience that. So that's why they just kind of freeze everything and wait for the court to decide how to proceed. So again, this is a protective measure. But don't go and fire off these statements of interest unless you are really close to being prepared to have your court hearing, or you have more than $20 hiding under your bed mattress just in case your account gets frozen for 10 days. Things of this nature. So have that in the back of your mind, because this is about the 5th time this has happened. So consider this to be a precursor or something that is going to happen to you. Okay, so we're asking for all the reliefs that are owed to us. Okay, so we got the special and the general, private and public. That's essentially what's being represented here. This prayer is nothing more, in fact, than all of the claims, paragraphs 1, 2, and 3 that we put in the stating part of our bill. And then we reiterated it in our charging part of the bill. Remember, all we did is turn it into a question now. So now we're suggesting that those 2 things make up the claim that this prayer for relief is now connected to, it is consistent with. And we're going to add a few more words here to make these claims and arrange them in such an order that they seem as consequences of the other one. As again, this instance or this event led to this, Your Honor, then it led to that, Your Honor, and then this happened, right? Okay, so again, that evidentiary chain of events. We're literally just reiterating it. Now, they don't want us to go into the details here. They don't want us to literally cut and paste the exact paragraph that we used in our charging part and our stating part. They don't want that in the order for relief or when they're granting you the remedy. No, they just want you to say something about, well, and the particulars alluded to and charged in the affidavit attached to a schedule, They are suggesting that it's out there, but they're not actually going to take your paragraph and mix it into the order, because you're going to have to produce that order at some points of your life to go and do certain things that we want to do. Now, that is a whole bunch of private information that does not need to be made public consumable, which is why you actually will not see it in the order. You'll see elements of it, maybe a date, maybe an intention, maybe something filed somewhere, I don't know, but they'll just have little like loosey-goosey things that describes the event. And this is just to protect you all. So when the circumstances of the case admit, there is in general added to the above prayer, just before its concluding words, what is called an alternative relief. Okay, so I've just touched on this. A relief which differs so far from the first relief as to be the same, but with a modification only. Or else are such relief which is quite as much warranted and supported by the statements or the charging part in the bill in all necessary points. So we literally create the thing, we make it exist, and then we lay a claim to it. And now we want relief based on those two. There's your trinity. There's your bing, bang, boom, out of the ballpark. And again, no man or woman, never mind a corporation, can butt their nose into this and rebut anything you are doing here. This is why these ex parte fast motions in court happen fast. Again, the clerks can issue a lot of process here just based on looking at your paperwork. You can literally walk out of the courthouse, or if you wind up doing this all online or through the phone system, again, we have a few methods of execution here. We get put into a position rather quickly where you're going to find out, oh shit, I don't know the answer to that one. Crap. Now what, right? Okay, you know what, Your Honor, or clerk, I'll be right back. We just hold on here, or whatever. Point is, we want to go in a little bit heavy. We want to go in with a little bit more knowledge and a little bit more, what would be the word, a feel for the situation, where you can, again, dance your way through a couple if you have to bluff, but we'd rather not be in a position where we bluff. That position of confidence is where we want to be. So let's just talk about, okay, here's the alternative relief again. This is a request for a remedy where the plaintiff is unsure of the type or exact relief they are entitled to. Again, when I pray for relief for an accounting, do I know what accounting truly encompasses? Well, no, Your Honor. That's all math. That's all ledgers. That's all trustee stuff. I actually don't really have a clue what's going on in the background there. That's actually none of my business. And this is enough inquiry on my end that's going to warrant the court to grant the accounting. What's going to grant the accounting? Well, here's another tidbit. When we pay monies into court, when we furnish the court with securities, when we provide a bond to securitize an equitable interest, again, we're bringing incredible value to the table. We're literally bringing a nuclear bomb to a knife fight. So who wins in that situation? Well, that's a silly even question to throw out there. However, that's the proportionate difference between a loaded equity claim, capitally funded with an executed trust. You have so much power compared to what the at-law legal stuff is thrown at you. We just had to be in a position where we knew how to negotiate some of these terminologies, to show the judge, hey, yeah, I have done a bit of research and I have tried drafting some documents, albeit they're my third attempt, Your Honor, and they're probably not that great. But I think because equity regards substance over form, you're going to get where I'm going with this. And again, we don't need 5,000 words or 50,000 words. We can pull this off pretty quick. But with the one page that we do produce, we want to have our heads wrapped around it pretty good. Okay, so this is where I got cut off in the introduction to tonight's video. What I was saying earlier, because this is a nice segue to that, the direction and what we're doing right now with the program is because there's about 10 or 11 components to the bill or the petition. We're at about part 8, part 9 right now of it. There's a couple more to go. Once that is all done and we have a nice reference and a nice resource to draw upon through these videos, I'm going to release the deed of trust, some working court documents that you can start practicing and filling them in yourself and get ready. And then it's a matter of polishing up your affidavit and then firing this off to the court and sitting back waiting for an email to show up, at which point be ready to go. I'm not suggesting it would be within the next 24 hours, but what this is doing is that it's putting some material, it's putting some substance into the hands of people that have been studying this stuff for a while and their pants are on fire. They want to do something because they feel the clock ticking and they feel that they are in a position of relative comfort where they know they're walking into a court situation here under their control. They've done a whole bunch of stuff. They know that this is not like being dragged into public court as a defendant, facing jail time. No, no, no. You are to be walking into this situation with a smile on your face. Wings. Know that you've got something, that you're standing on something, and that the defendant has something that belongs to you. And you're, by your good graces and your honorable intent, are trying to remedy and settle a situation which you believe an incredible conflict has plagued it, Your Honor. That's why I'm here to correct a fraud, error, or mistake. So let's pretend now, a few days from now, we got the learned skill set people in this group. They've got something tangible that they can start developing their own package. Great. Get on it, loved ones. While you're doing that, I'm going to go back to the beginning, and we're going to simplify this and dumb this down even more. And we're going to start again and let her roll in proper sequence with even more expansion, with less big fancy words. And if the learned individuals wish to still be a part of those, great. But again, once you start chewing on this stuff, and again, that level of passion kicks in, because you actually feel like you're going to be feeling like you're in control of your own destiny for the first time in your life. So you want to better believe it, that you start getting obsessed and very compassionate with this stuff. It just happens. I see it happen in individuals as I'm talking to them all the time. Just a 5-minute conversation with people can turn into something incredible. As a matter of fact, I'll let Jody explain one day about an instance she just had at the gas station here yesterday. It's pretty funny. Point being, moving forward, this way I can have, people with advanced skills or more advanced skills, they're off on their own. They're charging, they're getting stuff done at their own pace. And then they're going to come back with more questions. And again, I'll work with them as a team at that level. Plus, I get to introduce the round 2. And you know what, loved ones, eventually, we're going to turn this into a storybook for children. We want to make this so easy, like nice watercolor pictures and everything. Make it consumable. I'm not kidding when I say to an advanced starseed child that I see walking around out there, you don't think they can get their heads wrapped around this when they're 5, 6, 7, 8 years old? Oh, yes, they can. Absolutely. I know this from firsthand experience. And I did not have a teacher, and I did not have a group of loved ones like children nowadays have, if they happen to be connected to you, or if they happen to know you. Beautiful place to be in, if you ask me. Okay, let's rip through this a little bit quicker. I get caught up telling little stories. Okay, so what is equitable relief? This term applies to the assistance to a complainant seeking a just and fair remedy from the court. Again, the at-law remedies are always stacked in favor of the crown, which is why you get screwed all the time. There's no equity in those decisions. It's brutal. This is why they have a maxim dedicated to this. Equity abhors a forfeiture. When the equitable system knows that you've been deprived of your whole life's labor, you've been taxed to death, you've suffered these sicknesses, these hardships, things of this nature. That's why equity abhors that. Equity hates it. It literally means extreme enmity, extreme hate. That's the difference here. This should get your blood starting to get warmed up a little bit. Equity hates it when our lives get taken away from us due to a mortgage that we had no idea that we were actually a part of, all because of some bankers back in 1933 thought that the Emergency Banking Relief Act was a good idea to benefit them, take the gold standard away, and screw all the public over. Yeah, fantastic system for them. Well, again, thank goodness that we're in a position now where we can finally start doing something about it. So equitable relief, equitable remedy, these are pretty much the same thing. And again, these definitions are pulled right from Black's Law, 2nd edition. Here's the thing with the Black's Law. Over the course of its evolution, you can see we're back in its earlier years, they were very equitable focused. And then after 33-ish, and just prior to that, the editions of Black's actually started to change. You can start to feel a banker's influence. You can start to feel a more commercial, a more legal influence over the definitions in the words. So again, these are just ripped from Black's, but go ahead and do a little bit more digging on some of the other equitable masters. Story, Pomeroy, Gibson, those guys. Again, that list is long. So this remedy occurs when a fine is not fair. How do you impose a fine for having lost your life? If you're 63 years old and we literally signed that, or we pledged that right, that liberty away when we were about 14, 16, maybe some of us did it to go enter World War II. Point being, we at some point made a declaration of majority. However old you were, that's when the clock started. And if we are 63 years old now, how do you impose the value of a fine based on that 50-year window? Impossible. Who knows what you could have done with your life estate when you were 16 years old? See how that's virtually incalculable. So that's why they don't even bother doing it. When a fine is not fair, we're gonna ask for, or we're gonna pray for a different kind of relief. We're gonna ask for performance. We're gonna ask for enforcement of a contract. But keep in mind here, loved ones, a trust is not a contract. They are not. They are fundamentally different. And here's why. A contract usually requires agreement of both parties, correct? Of course. A trust doesn't need the agreement of the trustee. We don't give a shit if they don't want it. They have to do it. Why? Because no trust can fail for want of trustee. That's why the Crown literally has the civil sector versus the public side. It's almost 1-to-1. There's almost one civil servant to one privately residing individual, if you want to call it that. That's how many people are working for the government nowadays. It was mind-blowing when I heard that one. So here's the deal. The trustees don't need to be notified that the trust exists. The judge is just going to order them to perform. They had no opportunity to even agree to a trust. That's the beautiful thing about trusts. Again, back in the day, Dean and I were all about contract law, contract law, contract law. Okay, well, that's great. But when you don't have agreement of the other party, how far do you think you're going to get that contract to hold weight and prove your cause of action in a court of competent jurisdiction? You want to know how far? Not very. So rather than argue contract disputes, let's focus on trusts. And let's get that trust converted and get that into their possession, their hands, so that they can act appropriately. So again, a fine doesn't get the job done, so don't even ask for it. And fine turns into damages right away. You'll never see us use the word damages in our claim. Why? Because damages is legal. When you have an equitable claim and a legal remedy, boom, your case just fell apart. Don't ask for damages. Ask for compensation. I know that might sound ticky-tack, but you know what? There's a huge difference between the two. Big. So an equitable title is an enforceable title to ownership of property that has been recognized in courts dealing with equities and is based on fair and equitable principles. So do you think you're going to get an equitable title when you're in the public at-law side of the sphere? No, impossible. Oil and water do not mix. Don't even go in there asking for them. I mean, don't get me wrong. I say that now as so matter-of-factly, but a fellow loved one of ours just up into a year and a half ago, he's rolling in there and we're commingling and he's mixing and the judge is asking him what kind of relief it is he's actually after. And he actually said, I don't really know. So then the judge is like, well, did you write this? And my friend's like, well, no. So then you can see how he's barking up a tough hill right now. The judge is appreciating his effort, but the judge also knows, hey, you're not quite ready. So here's a couple of rules and necessities, a couple of points as to how we want to be drafting these prayers, taking this a little bit farther. The prayer for relief is said to be an alternative prayer when such other relief is sought. Again, like the injunction, the accounting, performance. And this second relief begins with the words, or that the petitioner is entitled to this relief. The chief point to be observed as to the prayer is this: to see that it is consistent and no way multifarious. Okay, so what does the word multifarious mean? It means many and of various types. So this is where I was suggesting earlier. Don't start praying for an accounting and an injunction, a specific performance, and further process to issue and all in one bill. It's just too much. It becomes a clerical nightmare. Let's get the injunction down first. Let's get the stay of proceedings down first. Let's get everything stopped, seized, held. Let's get a receiver appointed. When the courts when the court, I'm gonna try that one more time. When the courts appoint a receiver, that means someone just picked up a legal title that you threw at them. This is what a receivership model is all about. They throw it into the bankruptcy court proceedings, but it has sort of to do with insolvency acts, but not really. You can actually use a receivership model or a receivership order to restructure a corporation. It doesn't necessarily have to part with any assets. It doesn't necessarily have to pay for any bills at the moment or any debts. All it's doing is getting a restructuring of how things used to be regarding ourselves, and that birth certificate may be a beautiful thing to be looking at, Your Honor. I need a restructuring here. I know I volunteered to be the trustee and the liable party, primarily liable back when I was 16 years old, having not understood and unknowingly made a mistake. Your Honor, I didn't know what the hell I was doing. I was a bit of an idiot. Mom and dad sure didn't help me out in this regard. And therefore I fell into a trap. I fell into a pit. I fell into nothing but sickness and death. Yeah, Your Honor. But I have recently come to realize, so now we can move on. The multifarious thing, again, is a whole bunch of stuff into your and or they're seeking one at a time. That thing away from us.
Just one moment, guys. All right, guys, I will stop the share and I'll switch it over to my screen, and then I will do my very best to deliver the information to you guys. Just give me one moment.
Okay, can you still hear me?
Yes, we can.
Okay.
Hey, Darren. We can't hear you.
Okay, so if you can still hear me, I'm gonna let this go. Okay, so there's a couple of things that decide whether your bill, your prayers are multifarious or not. Again, your prayer for relief will be fatal. It actually says it'll die. It'll be no good, as it renders the bill totally inoperative. For such distinct subject matters ought to have been appropriated to separate bills. And again, loved ones, these aren't my words. I'm pulling this right out of Gibson's books. Okay, so let's bring these claims properly in the proper order. And once you get the first and halfway through the second one done, guess what? The judge will literally walk in and start to fill in all the blanks for you anyway. So you don't need to worry about a whole whack of processes coming up here. No. We just had to get the ball rolling. Equity does the heavy lifting for us once we get it rolling. Okay, so the relief, as is mentioned in the prayer, but when the bill actually prays and account or for discovery, here is, rather than praying for a bunch of stuff in one bill, let's break up the tight for each specific thing that we're after. The judge could literally just look at all of them, and now he can grant order these things
Cutting in and out, Darren.
when we have to do stuff at land titles, they want us to fill. Okay, am I okay now?
You're breaking up quite a bit.
Okay, then Kim, if you can still hear me, just roll through the rest of the petition stuff here, or Serena, whoever wants to read it, and spend 10 or so minutes on that, and then see if my internet picks up a little bit. How's that?
That sounds good.
Okay.
Perfect. Okay, I'm just trying to find the spot where he left off. He said the prayer is then said to be for discovery and relief, but is said to be for relief only when there is clearly no particular discovery necessary nor sought for, and for discovery only when a discovery only is sought for, and no other sort of relief. The bill must contain not only separate and distinct matters, but such that that each entitles the complainant to separate equitable relief, or it is not multifarious. Example prayer for relief drawn out of Gibson's. Complainant is advised that all of the said proceedings in the case after the filing of said bill petition, so I'm just going to mute my other computer, were and are a fraud upon your honor's court and a fraud upon the complainant and contrary to good conscience and good faith. And therefore, the premise considered, he comes into your honor's court and prays, first, that all proper process issue to bring the defendant, John Doe, into your honor's court and to make him answer this bill, but his oath to his answer is waived. Second, that an injunction may issue by fiat, enter the definition. Oh, we'll enter that next time, sorry. Of your honor restraining and inhibiting the defendant from further proceeding in the enforcement of said. So Darren did say before I started reading that we will go back and cover this for you guys. So he's going to enter all his Darrenisms in between. We'll include that in another Zoom or whenever he logs back in. And from transferring the same, and your honor, grant complainant the temporary injunction addressed to the said, whatever it is that you guys want, requiring him to stay all proceedings on said execution until further orders of your honor. So here's that definition. Okay, you guys have this document, so I will just continue on to remedy, the overview. Declaratory remedy gives a declaration of rights without providing the basis of transferring anything of value. Most common, declaratory judgment, which performs much like an injunction without coercion. Money damages, the money substitutes for the action of the thing lost, like good health, wages, bills, torts, which we'll cover torts later, and tangibles. Specific remedy, give the actual thing lost or want. Injunction prohibits, requires conduct. Specific performance compels performance of whatever you mentioned. Replevin, return of personal property. Ejectment, return of possession of real property. Constructive trust, return of money and property. Remedies, compensatory remedy, compensate for past harm measured by loss. 2, money damages most common. Preventative remedy, prevent future harm such as via injunction. Restitutionary remedy, remove, I believe the triangle, it was just copied and pasted, person's gains. Purpose is to disgorge gain to the said complainant rather than compensate for a loss. Can be substitutionary or specific. Remedies to deter or punish, usually in criminal justice system, but punitive damages can be imposed in civil justice. Supplemental remedy, assist in accomplishing objectives of other remedies, enforcement remedies as supplemental.
Can you hear me now, Kim?
Yes, we can. Please come back.
All right, I'm back. Okay, yeah, that was pretty good. Thanks. So again, we're just going over some highlights here as to some of the mood. We're just kind of setting the ambiance really of the environment that we're about to walk into. Again, equitable remedies here do not mix legal stuff. That negates or that renders our filings fatal right on their face, which is why a lot of times the clerks are rejecting our stuff as soon as they read it. Well, why is that? Well, and that's not because we didn't go to law school for 7 years. It's because we're actually mixing equitable claims and legal reliefs. Big no-no. So, okay, I guess with respect to equitable reliefs, the specific remedies, they're almost always equitable, with the exceptions of replevin and ejectment. Now, ejectment is something that we are going to get into. This is where we literally roll into a situation and eject them from the position that they are currently in. This is another way of saying the subrogation. When someone, when a fighter pilot's and he hits the ejector seat, he's no longer in the plane, is he? No, he's somewhere else. Who's now flying the plane? Well, that's why we got to put those new trustees in there. That's the subrogation. The replevin is a specific claim where we are talking about personal property. Now, this is where we start to mix in the chattels or that specific security certificate. This is how it's through the a writ of replevin. It's almost like consider the word replevin like they're replenishing something. Okay, I think, oh yeah, there you go. Okay, so the replevin is the return of the personal property. There's another process is called the renvoi, R-E-N-V-O-I. If you did a quick Google search on doctrine of renvoi, this is a French word mixed with a little Latin, and then the English grab it and they start turning it into it should be, or it ought to be returned. Something should be returned. Okay, well, if you can identify what the something is and who you're going to turn it to, that's under doctrine of renvoi. Okay, so the constructive trust here is super important. When you start dealing with the trusts properly and the judge can actually get his hands on it, he's going to be able to put you in an incredible position. Now, take this just to chew on it. I'll let you see how far you can develop this one. I know Dean and I and many others, we're always talking about being the beneficiary, being the beneficiary. How about really we can structure this where, what if the public becomes the beneficiary and we just stayed kind of in the settlor grantor position? What if we created a trust that's absolutely in the public interest? Would they not be obligated to deal with that? What if we kind of built that around a charitable trust? What if here, take your security back, you become the beneficiaries, you get to own a certain interest in it where you get to have possession of all the paperwork side of the deal. You get to be renting and selling the papers. You get to be doing all that commercial activity with the papers. And while you're turning a profit with all of the paperwork, you'll get to have use of property. So again, remember, there's two entities, themselves and that certificate. There's two parties present here right now. So if we can spin in a third party, or if we can spin in a court process to get these trusts recognized, where, hey, maybe what if we did style the trust so that the all caps was the beneficiary? And what if the man is just the settlor over here on the side? I mean, these are little things, these are little nuances that we're going to start to play with here. Because again, expect the Jesuits and all this old doctrine that applies. There's going to be all kinds of little twists and turns and things that we didn't expect, and things that these little roadblocks and these speed bumps that they would have put down in front of us, prevent us from finally escaping Egypt and Babylon. And again, right down to the silliest little thing, they're literally taking advantage of it, and they're hiding it, disguising it, or perverting it, or bastardizing it, whatever they're doing to it. They left no stone unturned. So all I'm suggesting here is that we do have the capacity with the minds, even present at this meeting tonight. Some of us can go off and start spinning these little ideas in our heads. Yeah, okay, and we can develop this stuff a little further. It's just something to chew on while we're doing this paperwork for ourselves. So some of these remedies, are again compensative remedies, not damages. We're not seeking money. Again, your servant is your money. That's right out of scripture. So why are you going to go ask the judge for $100 billion? Wrong. Ask for your servant's performance. You'll get the $100 billion, but without you getting dirty hands by asking for $100 billion. And again, I'm just throwing a number out there. But point is, your servant is your money. Seek another man's wealth. What if that other man was our creator? Seek that wealth, not the one you want to go and labor for, break your back for every day. There's a treasure chest full of stuff that we have access to. If we meet the conditions and if we fulfill the obligations and duties to entitle ourselves to access it, oh, it's there, all right. Otherwise, scriptures is completely false. And then otherwise, all these codes and statutes that they used and created to undo the scriptures and its doctrine, they're also false. So if you look at the amount of energy put into scripture and the legal system to classify both of those entities as being false and not true, I don't think that's reasonable. One of these things is the truth. It has to be. So moving forward, again, the remedies, legal versus equitable, the rule of thumb usually states that specific remedies are actually equitable. These are the ones we were talking about, the special ones, replevin, etc. I guess we can probably scroll down a little bit. I guess this is me in control here. So the differences are which type of remedy will determine whether you can get the remedy. Makes sense? Who will be the fact finder? How the remedy will be enforced? And what defenses the opposing party may raise? Again, this is why when we were asking in those questions or in our charging part, in our stating part, we said, and Your Honor, and our defendant here sometimes pretends that we're not entitled to our birthright and that we're only entitled to a portion of it, whatever he thinks I should have. But I'm here to charge that that's bullshit. And I'm here to assert the complete opposite to be true. And I'm going to aver the following, right? Then provide your little list of stuff. An inadequate legal remedy is an explicit part of some equitable remedy tests, such as injunctions, rescission. Okay, and again, anybody who's been in this journey for any time now, you've heard Dean talk about rescission. You've heard a few others in this movement talk about rescission, right? Like that's where you can literally go back and remove your signature from a particular document. You literally rescind it. I'm suggesting rather than do that, we can actually accept the fact that we created a situation unawares, right? We didn't know what we were getting into, Your Honor. So rather than rescind it, let's just go with it. Rather than create a whole bunch of extra work, let's just assign that interest, or let's just vest that interest into the proper party. I was never meant to be the debtor. I was never meant to be liable. But due to Satan's little slipperiness, I unknowingly jumped into that pit. Right? So, Your Honor, we're here to fix that mistake, that fraud. So, again, a constructive trust. This is super important too. This gets mixed in. The equitable lien, which is a part of our trust. Really, again, we're talking about kissing cousins right here. We're talking about substantive materials that are so close in their nature and how we're directing them. But these things play an incredible tool in our toolbox that we really need to get our heads wrapped around for a court to grant the remedy. Now, here's a neat trick. People say, well, how come there's never jury trials in equity? How come we never hear of people talking about this stuff? Why? Because there are no juries in equity. None. Zero. Juries are only on the public common law at-law side. Why? Because a single man or woman with the powers that have, they have a lot of powers, they by themselves act as the jury. As long as you can provide enough proof to the master who's going to make a report, and based on his report and his findings, she sends that to the judge. The judge quickly looks at it because, trust me, loved ones, that master, this is their job. They went and they did the accounting on your estate, life estate, your trust. They got a whole bunch of stuff. They know the formulas. They know all these algorithms. They do these accountings. They create this big friggin' report. Everything's perfect. The judge just quickly skims over it and proves it. How much time of the judge did we waste? Not much. He spent 5 minutes on it versus sending the judge all of our entire package and expecting him to go fiddling through it to look through, all the shit it is that we're trying to do. We're actually doing a bit of a disservice. We're actually asking a little bit much from the judge. He's literally got better things to do. So that's a bit of an imposition on our part, where I would definitely recommend and suggest that we only bring our stuff to the master. Or you could say, hey, judge, please refer this to a master because I don't want to waste your time. Let the master go do what they want to do. Again, they got a lot of powers. They can literally grant everything that we're asking just themselves if we give it to them in the proper fashion. Okay, so, again, people, they understand what torts are. These are legal remedies. If you hear people talking about torts as part of their remedies, it's straight up legal. Stay away from it. Don't mix tort damages, et cetera, into your equitable pleadings. I don't really need to go over much into this area here. But if you wanted to grab a couple of snaps, I went through it pretty quick, but trust me, there wasn't a lot of meat there anyway. So short-term injunctions. There's a couple of types of injunctions going on here. You have an interim injunction. That's a temporary one. That's just whoa, slow the show down right now until we can get our heads wrapped around this, Your Honor, because we don't want any trespasses. We don't want any breach of trusts, things of this nature going on. So we need an interim, we need a short-term injunction to happen right now, Your Honor. And then once the dust settles, now you can grant the permanent injunction. This is where we're going to pray in our prayers for relief. We're literally praying for process to issue, process to get this thing started, but it doesn't end there. Your Honor, we're actually seeking further process to issue later on. So again, these little things, these nuances, these little perceptions, these little details, when the judge sees you using these things as part of your tools, he sees that you've done some homework. He appreciates the fact that you sort of know what the hell is going on. And again, we're not expected to know everything. Shit, I've been doing this a long time and I'm just scratching the surface now, is the way I'm kind of figuring it. But again, let's help the judges. They're not our enemies. Treat them with respect, things of this nature. Help them help you. Don't go in with a shitty attitude. There's nothing worse we could be doing, loved ones. So a party seeking a short-term injunction must post a bond. Whoa, what did that just say? A party seeking a short-term injunction must post a bond. Anybody that's been studying this shit for any time is going to sort of get a little tingly feeling there. What does post a bond mean? Well, now we're dealing with securities. Now we're dealing with specific things relating directly to that birth certificate. When you walk into court with no bond, that means nothing is bringing value to anything coming out of your mouth. You could literally get on the stand and lie. You could literally tell the complete false whatever that you were trying to tell the judge because you have nothing to lose. Can you imagine showing up to court with a $10 million bond where if you get caught telling a lie, they take your 10 million bucks? Okay, this is a whole put your money where your mouth is. If you don't stand on any value, guess what, public citizen? You got nothing. So we must bring a bond. So clearly we're going to have to get a security bond drafted up here. We're going to have to get a cost bond drafted up here pretty quick. And then if anybody has any inkling to do any research on that stuff, have at it. Go see what you can dig up on that kind of stuff. Again, Google's fantastic for providing a lot of templates and a lot of working versions of these things. And again, the circumstances in some of those templates won't specifically apply to you, but you're going to get a good understanding, or you're going to start to visualize, I see. Oh, that paragraph right there is dynamite. That's exactly what it is I'm trying to do. And then take it, incorporate that into your document, start building these things for ourselves. Again, this is what the teamwork thing is all about at this point. We all can start coordinating here. We can all start contributing at some point. Because again, probably every third recording here is going to be dedicated to sharing and questions and exchanges back and forth, not just me sitting here, rambling at light speed. So traditional tests for all the jurisdictions out there, they must follow some sort of protocol, right? What are they looking for? Based on the success of the case on the merits, what's that subject material nature? What's that private awesome stuff it is that we brought in our pleadings? If we brought the proper cause of action, the likelihood of success on its merits is very good. That's why the judge is obligated or warranted to grant the order before the opposing party or before the defendants are even given notice of what you're about to do, because it's literally that solid. If you can prove there's a likelihood of irreparable harm being done, Your Honor, if this thing isn't addressed or dealt with right now, it's causing me irreparable harm, right? If you can show some of this stuff, again, this is the urgency criteria that you're going to meet, that the judge is going to hear your case right away. We've heard of a judge granting an order 4 hours later upon proper paperwork being given to the clerk. So, but again, this is a tight document. We got to have a lot of A's and Z's crossed and dotted to get that far. So we have to prove that there's a hardship. Your Honor, I'm going to suffer a hardship. I've dispossessed myself of the legal interest. I will no longer act in that all caps name without permission, or at least until an order of the court, or until the trust is recognized, or whatever the hell happens from here. Your Honor, I'm screwed. I'm cut off. I will not now disgrace myself again by acting in dishonor, because I know the watchers, I know our Father, our Creator in heaven is watching, and I will not piss him off, because that's going to be lightning bolts for me, Your Honor. So there's no way I'm ever going to act in person ever again, which means I cannot act, or I cannot identify as my driver's license, my credit cards, all that commercial energy is now done, Your Honor. That kind of puts you into a position of being in an urgent category. So is this injunction in the public interest? If we spin it properly, it is. Yes. As a matter of fact, I'll explain on another so why it's in the public interest both ways. But as long as we allude to one of them, point it out. Again, the judges are not mind readers. Give them a few cookies to chew on. And then after a while, they might go and get the ice cream, but you got to come with something. So the balance of hardships is important. The injunction is going to be in the public interest. There's that bond requirement again. Good stuff moving. Execution on that bond, moving down here. The execution is really, did you endorse it properly? Did you include proper indemnity to the trustee? Again, this is why courts and agents and trustees are very hesitant to act if you actually didn't give them some type of insurance. If you didn't say to them, hey, as long as in the ordinary course of business, as long as you don't screw up too bad, we've both got a lot to learn here. So I'm going to give and you're going to give, then I'm going to take and you're going to take. This is going to be a mutually beneficial relationship. Again, that's equity. Both parties actually benefit. They do. So moving forward. Specific types and sorts of short-term remedies. Again, here's that asset freezing order. That's what's happening to one of our loved ones right now. He's done it. He's poked the sleeping bear enough so that someone has come down and frozen stuff for him. Now, again, we have to take a quick look at, okay, so what are some of the things? What are some of the criteria? What are some of the entitlements that we have to get conveyed to this judge? So right now, we're looking at a replevin order. We're looking at a writ of possession. That means, Your Honor, I am being dispossessed of something and another party's being possessed of something. That is a writ of possession. You identified the property. You identified why it should transfer or change hands. You identified why and how you even had the thing to transfer it in the first place. So again, a lot of this meat and potatoes, a lot of this substance needs to be dropped into the body or into the corpus of our paperwork, so that the judge can actually see what the hell it is that we're talking about. Now, again, the recitals. Recitals is just a quick, brief overview, perhaps in 1 or 2 or 3 sentences, where you actually use 1 or 2 or 4 words in a little phrase to say, equitable title and petitioner. There's one. Who seeks the following, and then you're just going to give a brief outline in a few sentences. If you don't get your recitals structured properly, the judge he's looking at a very ambiguous document, and he can't read your mind. They can fill in a lot of blanks, but let's just show up with a lot of stuff. Again, moving down here, check that out. The legal title is required. So where is the legal title? Again, I know that we've talked about this on other episodes, and I know there's some chatter online about whether this legal title exists or not. Well, if you've got a security that's neutral in character, by your voice, by your written word, you can establish whether something exists or not. You can determine certain events, whether they've happened or not. This is what witnesses are for. This is what declarations, proclamations, affidavits, et cetera, et cetera, et cetera. That's what these things are for, to prove that things exist. So attachment, we can talk about one right here. I'm going to talk about something else here real quick. Okay, so the tangible property, it must be capable of being identified. It must be capable of being seized. If you've ever heard of a term, the plaintiff is seized of an equitable interest. Oh, there's a good one. You might want to put that in your recital. So attachment, right? When we're talking about a legal title, a legal remedy, creating a judicial lien. So we have a legal situation where we literally pass it off to the judge, the judiciary. A lien is created in the process on the property, subject to the attachment. The judge is going to do all of this with us, that there's a pre-existing legal right to possession of the property. This is actually required. The trustees are supposed to be in possession of that legal interest, not us. So in order to protect the priority so that the judgment ultimately obtained by us is actually going to be enforceable against the attached interest to that birth certificate. So they're talking right here, I think this is California law, but anyway, no showing of necessity required except when a certain party seeks an order ex parte. Again, you don't even have to name the other party. You can literally roll through this without notice. John Doe, Jane Doe, Your Honor, we know it doesn't really matter. You're going to tell me who the proper defendant is rather than me playing games and wasting court time trying to figure out who it actually is. And again, I've been doing this for years. It's going to be easier at this point to let the judge tell you. So there's that receivership again. Receivership is actually an equitable remedy under which a court appoints a neutral third party to run an institution or enterprise. It kind of sounds like Star Trek, pending on the outcome of the litigation. So what is the institution or the enterprise? Well, guess what? It's that little piece of plastic you got in your back pocket. That organization organized within Her Majesty the Queen under certain public codes and statutes is an institution. It is an enterprise. So permanent injunctions coming up. Once you get a whole bunch of this process done, the judge is now going to grant the permanent injunction. You know, again, once the master's report shows up, once they've done the accounting, once they know what your life estate is worth, once they've established how the distribution of assets is going to flow down to the beneficiary. There's a whole lot of shit that's going on in the background, loved ones. Again, we're just scratching the surface here. A lot of trustee stuff that we don't really need to know about, but as long as we got our heads wrapped around the basics of it, we're going to be in good shape. Again, so the Supreme Court of the United States, the way they're testing this, how do we know that a permanent injunction is proper? It must show that irreparable harm is going to be suffered if it's not issued. The nature of the injury is one for which the courts will not require a certain party to accept money for damages. Again, don't even ask for damages. Timing of the injury is ongoing or likely to continue to occur. Inadequate legal remedy, Your Honor. If I'm not asking for money as a damage, how is the aggrieved party going to receive justice? How is he going to receive, a balancing of the equities? Well, this is where that silver coin comes in. We're actually using money that trumps public tender. That's what forces the trustees to operate. They actually can't pay us back in specie, so they literally have to give us the beneficial use of property to make up for it. Nice deal. So supervision difficulties we get into. There's a few blurbs here. Again, this is all out of Black's Law. I just cut and pasted as we went here. There's freedom of speech. If you really want to get into that, I don't think it's necessary. Remedial defenses. When we're actually using the birth certificate as a remedial device, this thing is a device. Consider it this thing is like Pandora's box. We can do all kinds of stuff with this if we do it properly. Unclean hands is really important. The unclean hands comes up over and over and over and over again. If you're in possession of the wrong interest, guess what? You got dirty hands. Fix that problem first, which is what our petition is ultimately doing. So we must prove by misconduct that a certain party relating to the subject matter of the claim. As a matter of fact, Your Honor, both parties are at fault. Because a lot of us like to have claimed, oh, it's fraud, they screwed me, I didn't know, blah, 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 it's all fraud, fraud, fraud. Okay, great. It's fraud on my part and it's fraud on their part, Your Honor. Therefore, one of the parties is going to, actually, can you believe it or not, both parties now wind up having clean hands. The trustees get what they're supposed to have, right? So now they're clean because they weren't supposed to have the beneficial interest. It was our screw up when we were 16 years old that created that problem. So imagine creating a problem and then just sticking it to somebody. How do you now feel like you're getting screwed over? Wrong. Right? We mucked up in the beginning. So they're going to get themselves cleaned up. We get cleaned up in the process. Everything's clean. Clouds and titles get put into their proper capacities. Estoppel, again, that was another catch word that we were using back in the day. Estoppel is legal and equitable, so careful just how you use it. But that one is one that can float between the two realms. Promissory estoppels distinguish that it's not a defense, but a way of establishing a cause of action. That's actually a pretty good one, because establishing a cause of action is one of the harder things to do to get this petition rolling, believe it or not. So we're going to go after something like unjust enrichment. Your Honor, the state is not supposed to be in beneficial possession of that interest. They're unjustly enriching themselves. And the only way to correct this is to allow me to have access to that unjust enrichment. Ta-da! That's how this thing is floating back and forth. So I think we got about 10 minutes left, because we're going to make up for some lost time due to our technical difficulties there. So if you want, Kim, maybe just scroll through this a little bit more, maybe do a whole page at a time and just let them snap this. I don't need to talk about it a whole lot. It's pretty self-explanatory. We're talking about presumptions, and here's ejectment again. Transfer of title is involving ejectment is the legal remedy to remove people mistakenly in the wrong position, right? So these are things that we can use to get presented to a judge that's going to get us in a much healthier state of affairs. So I'm going to just take this moment, loved ones, to describe our situation here with our internet is basically putting us into a position where this is getting worse and worse and worse and worse for us. So I think what's going to happen here is we're going to spend the next day or two going over at a failing rate. It was what it seems to be like here, until we get some better internet things fixed up for us. I don't want to be just doing anyone a disservice. So what we'll be doing in those next 3 days is I'm going to be doing my best to get one of those documents or two into your possession so that you guys got something to chew on. Because Jody and I were supposed to be out of town. We got some personal things to deal with as well. So we are going to be taking about 5 days-ish off from Dï5 Live, Divergence Live. But I mean, this is just a one-off 1 hour conversation. I will still have access to the Telegram chat. So let's light it up there, and Facebook. I will make our presence there. And as a matter of fact, to make up for the not being live for an hour, I'll probably be in a position where I can go on there for 3 hours a day. So feel free to fire questions, start sending me an example of what you're doing. And again, this is where the sharing and the caring is going to start coming in. But again, it's going to get you guys active. Instead of just sitting here listening to me ramble on about stuff, we're going to actually get some working things moving. Because when you feel like you're putting pen to paper and you're getting your interests expressed, it's a very gratifying feeling. And like I said in the beginning of this episode, it'll charge you, it'll get you excited. And loved ones around you are going to sense that. And they're going to say, why are you happy? Because you're going to finally feel like I'm actually doing something to help myself. It's an incredible spot to be, loved ones. So can we get a question maybe dealt with, Kim? Is there a good one or two kicking around? I don't even know if you guys can still hear me, to be honest.
Yes, we can.
Okay, fire one off.
All right, sorry, Darren, I couldn't unmute myself. So the first question we have is, can we seek an injunction for the mask wearing in vax?
Oh yeah, absolutely. There's a good one, right? They're giving us an emergency to go and create a problem. Your Honor, I got a conflict with that whole situation, and here's why. Boom, 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 boom. Essentially, they're trying to end my life. This is the way I feel, assert and believe that to be true. And I have a bit of a problem with that, Your Honor. So you're going to grant that injunction. And it's going to be kept private. I promise I won't go online and splash it everywhere. But I'm going to share it with all my loved ones because I think that's fair. Right? Point being, that absolutely opens the door to get an emergency petition filed for the following reasons. Now, you may have in your charging or your stating part, you're claiming that public policy is now starting to harm you. Now, okay, that's still part of your equitable claim. Yeah, that's okay. As long as you just don't start mixing in public remedy under section blah, 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 and code under section and statute act this, that, and the other. Just don't bring that in, right? Stick to your injunction. That's it.
Perfect. The next question we have is, can we still use the credit cards, etc., as beneficiary of that account? Not as the owner, but really as the beneficiary.
Yeah, we can, but we got to get a whole bunch of that back work or a bunch of that foundational agreement done in the background. And this is part of the process where we're finding as soon as we start sending off some of these trust expressions, as soon as we start sending off some of these security or administrative agreements, that's when they're shutting your accounts down or they're freezing it. So they're like, hot potato, hot potato. They don't want to touch it until they have a court order or until the attorney general authorizes them to proceed. Because you know what? They do want, here's why they don't want to touch it. They think we could be laying a trap for them. And if they jump in and they go make a mess, and now we can actually attach unlimited liability to their bank based on their breach of trust. Do you know what just happened? You just became owner of the bank. That's actually happened to our colleague in the United States through some of his students. So that's why they take this stuff very seriously. There's a lot at stake. We want to make sure that these processes are done properly. Again, that's why I'm going to the court to get help. Again, people that want to accuse Divergence of acting fraudulently, are you fucking kidding? We're going to court to get help, to get all this done. How or am I going to be held fraudulently doing stuff when I'm actually trying to go get this done on everybody's behalf? You see how asinine that is? And again, I just let the peanut gallery chirp their chirp. I don't really give a shit. It doesn't matter. I don't take that personally. I know what's going on in the background here. You got time for one more, Kim, or should we wrap it here?
If you have one more, it seems to be coming up a lot. It's what happens if they're landed immigrants and they don't have birth certificates or anything like that. I know we've answered it before, but I think this is one that we should address a little bit more.
Okay, yeah. If you are a landed immigrant and you don't have a single piece of government issued paper from or regarding anything, we literally just create an affidavit. We literally create a claim because now you're coming in as an alien. Funny how we were just talking about this the other night. Once you're coming in as an alien, believe it or not, an alien has the same property rights as a citizen. Yeah, of course they do. That's why they're to be treated with respect. So we can literally build a little package for yourself, where as long as you have a witness or two or three, go with you to, say, a notary who's going to notarize a particular declaration, suggesting who you are, when you came to be, where you came from, who your parents are, we can roll with that. That would actually be something that we can build as a deed, something that we can construe through a court process where we can actually get that filed or lodged at land titles or at the property registry or at the county recorder's office if you're in the United States. Point is that we can actually build that for you and get that working for you. One more, how's that?
Okay, perfect. This question came earlier. So who is responsible for providing the trustee, the grantor, settlor, or beneficiary? If it's the state and why? Can you just expand on that a little bit more?
Okay, so who's responsible for providing?
For providing the trustee, grantor, settlor, beneficiary, kind of delegating.
Okay, yeah. Yeah, that's literally us. We're the ones that does the providing. Can you imagine our parents provided the state with information that literally worked out to be not in our best interest as we matured? Okay, so when you hit the age of majority, when you hit the age of maturity, there's two things going on here. Not only do you hit the age of majority, guess what security or bond or shareholders agreement also hits its age of maturity? Yes, the birth certificate matures at the same time you do. So now that we have tangible things we can work with, we have competency and we got securities and we can do stuff with these things. Now we start mixing the two together. This is where the merger starts to happen. Again, the doctrine of merger is something that I would implore all of you to do a little bit of research into, because this is probably one of the two most important parts of the processes that we're doing here. When you have one title and a second title merge or come together in the same, you could say person or same individual, this is a merger. This is two titles coming together to become whole. The moment that it's whole, whoever's in possession of that thing has certain rights, abilities, and can do things with a whole title. This is very important. Merger is so important. So back to the question there. Yeah, the grantor, the settlor is going to merge these things and move them. The grantee has it, passes it to the grantor. The grantor, imagine it's like, when you're running around a track The grantee had the baton first. He does his lap, and then he passes that thing to the grantor. Now the grantor does his lap. What's happening in his lap though? Okay, well, that's the evidentiary chain of events. That's him laying down a trust deed. That's him laying down a security agreement. That's him coming to an administrative agreement with the attorney general, if that's what it is you choose to do. Point being, we got substances, we got a whole bunch of stuff, Your Honor. We've wrapped it in a petition. We've got valuable consideration. We got collateral. We got perfected interest. We got so much shit going on, Your Honor. I don't even know where to start. But that's the whole point of these meetings, is that we're going to actually identify where it is we want to start. So getting these things started, again, we have all the tools, we have the equipment. We just needed to know the proper procedures, the 1, 2, 3s, how to put this down in proper sequence to get this thing to finally do what it was meant to do. And again, loved ones, this is where I'm suggesting we go to the court, because the judges are waiting to help us. They know what we're going through. And it's only us that can actually turn the tides for mankind. The judiciary cannot. They are an impartial party. They can't act for the government or against the government. They're right stuck in the freaking middle. And I know I got to wrap this up here right away. So again, we literally come in, take the handcuffs off the judge. The judge then turns around and takes the handcuffs off of us. We all work as one big team. We actually stimulate something called the judicial economy. This is the private side. This has got nothing to do with the public sector. The judges are Treasury. How do I know this? Chief Justice of the United States, John Roberts, came out and said it. I am Treasury, and what I do is none of your business, as he was addressing the public. What do you mean you're Treasury? And what do you mean the public's got no business doing what? Yeah, because it's all private. He knows what the hell's going on in the background, and what he does is none of the public's business. Love you guys. Till next time. Peace.